example, in the commercial wisdom of the banks or the financial institutions, we will not interfere. There is no question of it. But when we are talking of your commercial wisdom,
Yes.
we also know it very well that you are not a private entity.
No doubt.
The funds which you have are the public funds.
No doubt, my lord.
This money belong to the people of this country.
Yes.
Therefore, your commercial wisdom is for the purpose of giving benefit to a person, or it is to protect the public interest.
Which is not
That
the
will
case.
have to be investigated.
Greatest respect. But today, the case of the petitioner is a roving inquiry. He doesn't make out any case.
We are not concerned about the petition.
Yes, answerable to the court.
We will go to the extent that the petitioner has been planted by some rival. Somebody wanted to buy the hotel, couldn't buy. Let us take it like that, first part. But now that a fact has been brought to the notice of the court,
Yes.
we should satisfy our conscience that the things have taken place in a transparent
Yes.
and fair manner.
But which is what the court has said. You take the findings of the court, my lord. But finding after finding.
Just says one way.
Hotel was not without having any default prior to COVID. It suffered a default. The government of India, my lord, also issued circulars in regard to this period of default. If I have come out of it, they did try to sell. After that, I am back on my feet and I have paid. Is it a case?
We have no difficulty. Every day in and day out, in matters before us.
Yeah.
The plea taken by these very banks is, we will not enter into any OTS because the value mortgage by them is much more than my loan amount. Therefore, why should I go into OTS? This is the consistent stand they take before us. That we are not going to accept any OTS because we have an asset, we will auction it and we will recover entire amount.
Lord, is it appropriate that a man who suffers great losses during COVID, not a single room in the hotel was functional?
No, we are talking of had it this set.
আমি কোনো ভেদাভেদ করি না, না ধর্মে, না জাতিতে, না বর্ণে, না লিঙ্গে, না পাহাড়ে, না সাগরে, না মানুষে, না পরিবারে, না ধনীতে, না দরিদ্রে, না রাজবংশীতে, না মতুয়াতে, না নেপালি।
They are flourishing, they have wonderful business, each one of them making money. A 5-star hotel in Delhi has its own value, people know it very well. Who is going in the street, who is going to believe it, that this hotel has a value of 300, 400 crores? The value might be 4,000-5,000 crores.
It's not. Four valuation reports are on.
It was only 200.
Four.
The debt was 200, 250. It is settled at 400.
Therefore, two things let them produce. First, produce your ledger books that if going by the rate of interest and all as per the original loan agreement, what was the total amount as on 24th January 2025?
What is a special committee comprising of a retired judge and 4 other banks but this OTS was decided ultimately not by the bank alone. It had 5 people in the committee headed by a retired judge which decided what should be the OTS amount.
Then immediately produce this report. We would like to see the report of that learned retired judge also.
No,
Please produce that report.
I just want to make one small request, Your Lordship. I'm appearing for the bank. The committee consisted of 5 persons, a RBI nominee, a Government of India nominee.
If your lordship just says.
Besides the bank official, there's an RBI nominee, a Government of India nominee, and a shareholder nominee. They were all independent persons who had nothing to do with the banks playing any fraud in this case.
So,
And it kindly, therefore,
we have no doubt about their independence, Mr. Attorney. This all depends on what the facts are.
Your Lordship's question is certainly well placed, but the question
It is something like whatever in a writ petition or in a counter affidavit is brought before us. Based on that set of facts, we take a view. Our view, despite the fact that nobody will question our bona fide, nobody will question our independence, but still our view can be erroneous.
Exactly. We go by that.
It's not properly.
We certainly go by that proposition, but the High Court said, I've looked into all these aspects. Yes. High Court goes into an independent of the settlement committee. High Court says at 12:30, I don't find is a roving inquiry for no good reason.
Absolutely a non-serious, vague, bald, sweeping allegation on a bank, on a we are not defending every transaction. We ourselves come. But to say that therefore every transaction has to be 5 million transactions happen every day. If you are going to put a spokes to through a process to say that this should
Mr. Venkataraman, unfortunately, We are not saying that every transaction, but many of the transactions.
Certainly
that
not,
take place,
but
and
we are
particularly
provided.
under this, the direct or indirect umbrella of this IBC.
Yes, yes.
These have become a very, very doubtful manner. A poor lady, a widow woman came to this court. She was before us with tears in her eyes. She wanted to pay 30 lakhs to a bank. They refused because they wanted to 46 lakh. She lost her husband. That's why the default was committed. We had to come to her rescue only to protect her residential house. When question of that case, they said, no. The value of the house is more than 50 lakhs. We have to recover only 46 lakhs. Why we should enter into OTS? This is the stand these commercial wisdom people take before us. And when the question of a 7-star hotel comes, the stand is altogether different. Why our conscience will not pick? Why should we accept it?
May I only persuade on one aspect?
Please produce the report. I would like to satisfy myself.
Your lordship will do that. I only want.
So will be my brother. Let the original reports of
the settlement.
the bank, complete details of the loan amount which was due as on 24th January 2025, the report of an independent valuer, if any, assessing the
Four valuated should be
market value of the hotel as on 31st December 2024, that is immediate before OTS, and other relevant reports be produced.
There are four valuation reports converging on value, except for the one odd value report, which said, well, this is a hotel. We can't sell a hotel, but valuation demands, hotel cannot be sold as some industry. One odd valuer gives a report of 2,000 crores, which my friend is relying upon, who says it's a commercial property. It's one whole building is left out from the loan. Loan is not, ultimately the mortgage is only limited to a few sections of the whole. He values the whole as commercial, contrary to four bank authentic valuers who all confirm what this value of this hotel would be at a given point of time. Four concurrent valuation reports. Well, the High Court spent a lot of time. Well, we'll certainly persuade your lordship. No difficulty. But only thing, Lord.
We have recently, incidentally before my bench only, we have dealt with the auctioning of 2 hotels in Kerala. We have seen the people come forward to buy hotels also. There is absolutely, it's not that people there, the prospective buyers are not available.
We have no difficulty in producing them.
Understandable. Suppose you say that I have tried my best in December 2024. I could not auction it. I did not get a single bid. And therefore I had no choice but to go for OTS. We will accept it.
That's precisely what happened.
Commercial wisdom.
Precisely what has happened.
Not even otherwise.
We will produce the records. We'll produce the records.
Just see one page, my lord,
Which I suffered in
page
COVID,
252.
Will be sold. Approach that.
We are not saying.
It's not that I was not a default.
If a borrower, Mr. Aroti, if a borrower, small or big, if he can save his mortgage property by paying to the bank a reasonable amount, no difficulty.
Correct.
But not in this manner. If at all, it seems to be.
I think Lord, your lordship will be satisfied on the manner. Lord, I'm sorry, but your lordship will be satisfied. I think. But this,
Yes,
but this is an litigant who just using hammer and tongs will satisfy your lordship.
We'll show it, Lord. Absolutely no problem.
One page.
Lord, the other issue will be, can you really upset
Of the
cases
paper.
which are done in this manner?
When complete contrast cases come before us, we get disturbed only because we do not know what's happening.
Absolutely. There we are with your lordship.
But your lordship will be satisfied.
We'll have to cut the oranges from the apples, certainly.
OTSs are happening in this country. If not every
Yes,
matter is
Lord, he says this with a sense of responsibility. An extremely genuine OTS transaction is what has been brought unnecessarily into scanner. That statement we will make with
Say
you.
notice to respond number 4 and 5, 4 to 6 only at this stage. Number 1, notice to respond number 1, 4 to 6, and 4 to 6 at this stage. Then also report is before it.
Therefore.
I am obliged.
Oblige your lordship.
Sure.
But office report shows on 4 earlier occasions SLP is dismissed.
May I just place my matter, I'll place all of that, I'll place that, I'm for the petitioner. This is a writ. The only question, I'm pressing in this writ is my prayer A. What is happening? I'm not seeking any relief in respect of the matter, which is prayer B. The only relief is prayer A. Your Lordships will have at page 17. What is happening in the state of Telangana, my lords, is
Mr. Prasad, how many times your petition will be entertained?
because no writ petition. What has happened is page 237, your Lordships, I had come up in a SLP all the way, and at page 237 is that order where the liberty was given. My lord, just hear me for 1 minute. I see that, my lord, I have come in a SLP. Let me explain that, and the liberty was given at page 237. Your Lordships will have that order.
File SLP. Please see the order.
Yes, because page 237 is the SLP. And my lords,
Remedy. And you file another SLP challenging this.
no, my lords, I have filed only one SLP that was knocked out on the point of delay. The question was never considered. That came before Justice Narasimha's bench. The bench observed that earlier order. Yes.
Mr. Prasad, when
Yes.
that if we dismiss the SLP, we decline to entertain SLP.
Yes.
According to you, the second SLP is maintainable.
No, this is a writ petition. This is a writ. Well, the court indicated that please, we are not going to, because against the same, against the same order, the question, only the legal question, because in the state of Telangana, the court indicated that if you have to move, please move a writ. That's why they gave me a liberty. I am not seeking any relief in respect of this matter, but what's happening in Telangana, you'll also just consider one thing, my lords. What's happening is reserve candidates are being counted if they are meritorious against general seats. So, my lords, which is incorrect, because the law is very well settled. If I on my own merit make it in the general, then it has to be treated as a
SLP.
Plus, the SLP was dismissed on the ground of delay. So the High Court also didn't engage with this issue. The court at page 237, that's the order I had myself appeared, indicated we can't engage in this because I have dismissed an earlier order, earlier SLP against the same matter by some other party. Therefore, if you have to file a writ. That is why the liberty was given at page 237. And pursuant to that, I am filing. I am not seeking any relief or stoppage of the process here. I am only saying my laws will settle the law so that for future there is no problem in Telangana. That's the only prayer. This, your lordships may not interfere. My laws may record my submission straight away. I am not seeking interference with this process now. Because otherwise, every year this will be happening, my lords.
Thank you very much. We will not entertain this.
All right, my lords.
It has already closed the first round of litigation of this court with dismissal of SLP civil number 16170/2025. We are just of the view that the second round through this litigation is well in misconceived, misdirected and not maintainable. Dismissed.
Because I'm for the petitioner, these are two matters, but similar matters have been decided.
But these are fresh matters.
But these are fresh matters.
Any matter already pending where we can tag
Lords, as per the office report, no, Lords.
issue notice, justice, liberty to serve the state through standing conflict.
Most grateful, Your Lords.
In the earlier notice recall. Item 6. Already dismissed.
Please, Your Lordship. Lordship, this particular matter, as per the office report, this is already.
Other matters have already been dismissed.
Yes, Your Lordship.
Same order. Item 7.
Wait, Lord. I've just set out these, and just see the pleadings. Look, just see the pleadings against defendant number 17. I've just put them. Just hand it up. My lord may just see this. Look, I've just summarized, I've set out the pleadings against 17. Just see that for a moment.
Apply Order 1, Rule 10, discretionary relief. Why?
Order 1, Rule 10 too, but just see the pleadings here. Just see that for a moment. This is not, it's a case which.
A case cannot be maintained against a shareholder when the cause of action is against the company. That is your argument.
No, there's nothing against the shareholder. Just see the pleading. Ultimately, even against the shareholder, there should be some pleading. Just see that pleading for a moment. Give me, just indulge me. I'm not asking your lordship to open the papers. I've set it out here. Just let me read that, lords. I've set out in extenso. I've reproduced it exactly. Just see, lords. The solitary pleadings in the plaint with regard to D17, plaint is from 38 to 107. It's a 90-page plaint. Para 18, the 15 to 19th and 21 to 28 defendants are shareholders of first defendant and are therefore beneficiaries of the trades done by first defendant on the plaintiff exchange. Para 91, the plaintiffs state that in view of the fraud and default committed by the defendants are jointly and severally liable to pay the outstanding amount with interest in respect of the said outstanding trades to the plaintiff. Para 111, the plaintiff therefore submits that this is an eminently fit case to secure the claim of plaintiff by attachment of all the assets of so-and-so defendants, since the liability of first defendant admitted by them runs into hundreds of crores of rupees, and the defendants are consistent with an intention to defeat and defraud the claim, which is manifestly evident by the act of restricting inspection of exchange designated warehouses. Para prayer A is this honorable court be pleased to pass a decree and order directing first, third to 41st and 45th to 50th defendant to jointly and severally pay 937 crores. Now, they relied before the High Court on this para 87. Just see overleaf. Para 87, the High Court just merely sets out the para. Just see para 87. It is pertinent to mention that from September 2009, when the first defendant commenced trading on plaintiff exchange, till August 2013, the management and the affairs of first defendant was run
by the sixth and seventh defendant. In fact, sixth and seventh defendants were actively involved in the transactions entered into by first defendant on plaintiff exchange. The entire conspiracy to defraud the plaintiff exchange was conceived of and orchestrated by sixth and seventh defendant. It appears that the company owned by sixth and or seventh defendants and other companies formed I'm not a director. My father
was a director.
he resigned in 2013. Suit is filed in 2021. 8 years after he resigned as a director. No government against my father.
Sir, Roman 9, clause 9, Roman 9 of paragraph 87, that the shareholders are in collusion with the directors in respect of the fraud.
I'm not a shareholder.
You are a shareholder.
No, I'm sorry.
Paragraph 80.
It's a public limited company. I'm
Shareholder of the company, your plea for dismissal is no dividends have been declared, so there is no.
I'm sorry, my lords. Please just see the law laid down by your lordship. This is this opens
law
up.
laid down by us is not to substitute a discretionary order.
No, this is not a discretionary order with respect.
Absolute discretion.
Not 711 lies even with regard to if the entire plane can be rejected against one
Don't
defendant.
make advance arguments on 711.
Your lordship
Your prayer is under order 1 rule 10.
and under 711,
711.
11A.
If you argue
No
on
cause of action.
711, you are out of court.
Not your lordships
Cause of action is made out. Simple.
I'm not just see. I've set out the judgments also in this note. I'll tell you what. In Church of Christ, your lordships have categorically held that even with regard to an individual defendant, if the entire plaintiff can be rejected, 711 lies. Now there is no cause of action shown against me. Just making a bold statement.
Can entire plaint be rejected?
I'm sorry, Mr.
Can entire plaint be rejected when there is an allegation of fraud against?
Entire plaint has to be rejected. There's no allegation of fraud against me.
Doesn't matter.
Just the.
For that, what the remedy?
No, there has to be
Order 1
some
rule
basis.
10, order 1 rule 10 2 will make your defendant a party, a misjoinder. So for that, it's the discretion of the judge to keep him as a proper party. Simple.
I'm
It is not a
saying
party is a
your
proper-
lordships have said that just by some artful pleading, look at the nature of the pleadings here. With this nature of pleading, every shareholder or every company will.
Please come to page 26, opening line of ground C.
Page 26, Manoj.
Page 26, opening line of ground number C.
I'm sorry, just give me a moment, please. Ground C, the High Court failed to appreciate that in these circumstances, the petitioner only being a shareholder of. Yes, I'm a shareholder of defendant number 1. The description is only that I'm a shareholder, nothing else. Which means lacks of every claim against a company, lacks of shareholders can be roped in as defendants.
We agree with you. He is not a necessary party, but he can always be treated as a proper party.
But there should some averment against a party. I can understand if there was an averment that apart from being a shareholder, I have in some manner done some act, any act, even one act. There's nothing here, not a whisper.
Where is your most respected father in these days?
I'm sorry, Mr.
Where is your most respected father in these days? The whole country is eagerly waiting for red carpeting for him.
Look, only one thing, look, then let it be clarified that I can only be a proper party. Now, here, please see, if there's no absolute absence of any averment, not a single averment against a party, look.
Not a case where we will.
Please, the lordships.
Okay, for the petitioner, my lord.
Yes, I to meet.
Yes. My lord, without hearing me on the first day, my lord, I've got everything. Environmental clearance, consent to operate.
To the High Court.
No, I tell you, lordships, my lord.
they've passed this order, and now the next date is April, and running, my lord, I know the stone crusher, the moment you hear it, everybody nowadays has a prejudice, but then, my lord, for 3 months, I'm a small entity, I opened in December.
So you can request the court.
They've just, I had lots to say without hearing me. At least issue notice to me, my lord.
Therefore, if you have not been heard, please go and apply to the High Court. We will make some observations. You can approach the High Court.
My lord, may I just, my normal course, I should be.
Approved by an interlocutory injunction order passed against it by a division bench of the Uttarakhand High Court. Interlocutory order dated 7th January 2026 passed by a division bench of the Uttarakhand High Court. One of the events is that the order has been passed without even hearing the petitioner. So since the High Court is now opening after the summer winter break on 9th February 2026, first we say like this, it seems to us that the appropriate recourse for the petitioner would be to approach the High Court to appropriate applications for its impleadment as a party respondent, semicolon, to seek vacation stroke modification of the interim order, and to bring on record the set of facts which the petitioner wishes to, set of facts on the basis which the petitioner claims that the song SAUNG, Song River, is a non-perennial river.
Can I just, sorry.
Since the High Court is opening after winter break on 9th February 2026, we request the High Court to entertain these applications and pass appropriate orders by preponing the next date of hearing. With liberty of commensal, especially petition disposed of.
Can I just say one thing? I don't interrupt a lot. My submission is that the relevant stretch of the Song River is non-perennial. That is the permission. Lordship said Song Rivers, that is not my contention. I have produced documents. The document which they gave, is the reach of the Song River near Sankatiawala, Kala is non-perennial. That is my contention. Lordship will say relevant stretch of the Song River. That is my contention. My contention, even when I file a reply, is not, nobody can say the Song River is perennial or non-perennial. The relevant stretch, it's a huge river. This stretch, which is what the permission is given, the joint inspection report is on record, in which...
your contention that you are away from the prohibited area of banks.
Sorry, madam, sorry.
He's saying that the place where he's...
So, what means relevant stretch of the Song River? That's...
claims and to non-perennial that the site where the petitioners stone crusher, you have stone crusher is operational. The Song River at that near to that site is non-perennial.
Yes. I won't say anything for I won't read. Lordship may read annexure P10 how this order came to be passed. I won't say anything.
Perennial and at one point they even either perennial or non-perennial.
Lordship may see annexure P10. I won't say anything. Lordship may just read it. It was supposed to be listed along with a writ petition against my rival the next day. From this matter suddenly gets detagged and get listed. I won't say anything further. P10 Lordship may kindly see. I won't say anything further.
Anyway, we have requested the High Court to prepone the date and hear you. Reply immediately and get
the consequences are grave. One day without hearing a crusher stop, the small entity, the whole...
Mr. Vasan, these are environment issues. Precautionary principle guides the area.
But natural, this is not right. Without natural.
So, a precautionary principle, when there is an RTI report, the website of the irrigation department shows it as a perennial stretch.
Which is why hearing us under a given perspective. Anyway, I will
lost sight of facts.
I'll leave it. I'll oblige.
There are two matters before your lordship, 9 and 9.1. In a similar matter, Lordship, at page 212, next at P6.
2013 का डेट में
Same order.
Double 6/2065.
Others, we represent Ghaziabad Development Authority.
They are here.
I will respond in 4 and respond 3. The matter is coming out on 23rd of February.
Responder 4 only or responder?
4 in 9, we are 4, and in 9.1 we are 3. Respondent.
Accept notice on behalf of the sponsor respondent. Counter affidavit can be filed before 23rd February 26.
Please,
That they will decide on.
please, Mr. Oblige.
Then, there is a letter. Item 10, there is a letter circulating.
This is the third time, my lord, the petitioner has been reboarded forcibly and illegally by the MP police and the RPO with the RPO police. This is the third time this incident happened, my lord. He was not permitted to travel beyond his origination.
So what can we do?
My lord, this is a
How do we examine these facts that you were dropped on the way?
Well, I have filed the documents, my lord, that police himself given that letter saying that we are deporting you due to prevailing.
You don't have a place of protest in your state.
My lord, this is the case, my lord, where the.
No, you have a right.
My lord.
You see, we are not curtailing your right. You have a right to protest. Peaceful protest.
My venue is not empty. It is a venue of Delhi.
Yes.
My venue is not empty.
Oh.
In the midway, we were.
Mr. Consul, have you applied to Delhi government authorities?
Yes, my lord, that letter I have annexed.
Yes.
No reply. Kindly see the letter which I annexed. 4th of October, I applied for letter. I gave a letter.
Letter gave, have you obtained permission?
My permission. No reply has come.
If no reply have come, that does not mean the permission has been granted.
Well, even if I presume that even no reply has come after the representation is given, that means there is no grievance for conducting dharma at Delhi.
If you are ready to listen to us, then you please appreciate.
Yes, ma'am.
There is an earmarked dedicated place for conducting peaceful protests.
Yes, ma'am.
There you can have a political rally, you can have a non-political rally, you can have the farmers, as whom you are saying that you represent. The farmers can come there, they can protest for their demands, whatever. That's a part of the democratic process, no difficulty.
Yes, ma'am.
And for that, there is an earmarked place.
Yes, ma'am.
So first go to that competent authority, apply and obtain the permission.
When I gave a letter, there is no reply.
When
When I even the lordship say that I have to apply before the competent authority, I gave a letter.
Yeah.
Even if the letter has to be given in person, I have to come to Delhi at least.
Yes.
But even half of the way, I was deported.
How has he engaged you?
Pardon, my lord?
How has he engaged you?
My lord, he is probably in same place.
So for the purpose of Wakaltanama, for
No, my
purpose
lord,
of,
this is not the way, my lord. Kindly see this. There is a violation, a gross violation, 19(1)D and 19(1)A.
like to answer any question that we are asking you.
My lord, I am saying, my lord,
How did he come to sign your Wakaltanama and papers?
as a council, I have to sign it, my lord, that I file a writ petition on his behalf.
You are filing without any Wakaltanama.
No, Vakalatama I filed, my
Is
lord.
there?
Yes, my lord.
So he came to sign your Wakaltanama?
No, he said it by post, my lord.
Okay. He sent it from there. Now he has authorized you. Why can't you apply?
My lord, it is duly notarized by the local republic.
Very good. So he has sent it. Now you are his authorized representative. Not
I send it, then you should reply. That's why my submission.
Go and apply, please. Ask your clerk, you can apply online nowadays. You don't know to, even you are not required to go.
Well, I'm not saying, my lord, because the question is that the appreciation has been given. No reply has come.
Well, thank you.
Thereafter,
Thank you. No case to interfere with you.
well, at least, my lord, kindly see, my lord, the last date,
No case to entertain this writ petition is vague. Here you go. The writ petition is completely vague, evasive, and full of misdirected governments. This one cannot be entertained. This person. Roll pipe. And writ petition are disposed.
Earlier, my lord, I was given permission to go to the High Court, my lord. I applied for the High Court, I filed a writ petition. There also they said we have no jurisdiction to entertain because you were rewarded MP.
No, but your standard does not permit to go to High Court. You are not, your standard is not less than Supreme Court. So you are rightly come to
Went to High Court order also I annexed, my lord. After that,
Very good.
after dismissal of the writ petition, I went to the High Court.
All right,
I
thank you.
pleaded before the High Court.
Thank you very much.
There was
Thank you.
jurisdiction to stop anybody from MP, other than beyond jurisdiction of Madras. That
Thank
is the
you.
reason I come before Lord.
All right, thank you very much. Next. Item 12.
Lordship, I apologize in this matter. I'm sorry I couldn't circulate later on time. Mr. Sibbal, who's leading me, he's unwell. So he asked me to make a request. I got information very late. I tried to circulate, but I had surpassed the time. So I'm just requesting 1 week adjournment, Lordship. He's not well. I spoke to him. So.
Your monopoly right is expiring when?
Sorry, my lord.
May 2026.
Lordship, the patent will expire in May 2026. But there was an injunction till the time the division bench passed the order. So I'm just requesting for a week adjournment. There was an injunction throughout.
Next week. Next week.
Much obliged.
But if your lordship, so far as the SecPers lady is concerned, there is no allegation whatsoever. But please come to P4 at 61. That's the FIR. And if your lordships are kind enough just to see para 7 at page number 67. Apart from the invocation of 420, 406, etc. together, Lord, just come to para 7. Complainant, may I place it? May I place it?
Para 17 of?
Para 7 of the FIR, Lord, it said FIR will begin at page number 61. I would like your lordship to see para 7.
Yes.
The complainant ultimately advanced large sums totaling multiple millions of dollars, but as market conditions surged, accused persons began dealing, eventually ceasing delivery. So the whole issue is not, it's really a commercial transaction that we could not deliver because of change of market conditions. Others are surplusage and nothing against the lady, Lord. Nothing whatsoever against the second respondent in the entire FIR. Nothing incriminating. She's just been roped in because of relationship, Lord.
What is the stage of the investigation?
Lord, I must tell your lordship, I stated, Lord, charge sheet has been filed.
Let it be investigated.
No, Lord, may I just say this? My Lord, charge sheet has been filed in the interim while the matter was pending in the High Court. Charge sheet has been filed, but I have not been served a copy of it, Lord. Charge sheet has been filed. It really makes out a civil transaction. I have not been served a copy yet because right now summons are not. The process has not been issued. It's a case of not give or take of. Charge sheet was filed, Lord, but we don't have a copy. I can place that on record if your lordship permits.
Appear before the charge sheet has been filed, then go and.
And sorry, Lord?
If charge sheet has been filed, then go and see.
মহাশিবরাত্রি 2026-এ সবাইকে স্বাগত জানাই। এই মহাশিবরাত্রিতে শিবের সঙ্গে থাকুন।
Certain point of time. Kindly just see.
You know that is only prayer. That will ensure you will be released on bail.
And we'll take our remedies now.
Absolutely.
Yeah.
The petitioners are agreed by the judgment dated 22nd December 2025, passed by the High Court at Calcutta in Bracker Port Blair bench, whereby their revision petition seeking question of FIR number 34/2025, dated 13 July 2025, registered at Cyber Crime Police Station, South Andaman, has been dismissed. We we have heard Sri Siddharth Mitra and our senior counsel representing the petitioner and record and previously record. It is clearly admitted that that after investigation charge sheet has been filed. That means so, we are not inclined to entertain this petition. The petitioners, if so advised, may move an application for the discharge. Such an application shall be considered by the trial magistrate in accordance with the law. As per the law, with a view to enable the petitioners to join the court proceedings, it is directed that the arrest of the petitioner shall remain stayed. Say number 2. First petitioner company. It is directed that the arrest of petitioner's number. Petitioner is a company, Mr.
Sorry, not,
Petitioner is a company.
not number 2. Second petitioner. Number 2, not the Latifa Banu.
Petitioners number 2, sir.
And their second, 3 matters, not the other individual petitioners.
Petitioners in SLP criminal number 1790 of 2026 and SLP criminal number 12
We'll give the name.
825 2026 and so shall remain stayed subject to their surrendering before the trial court within 1 week and furnishing adequate bail bond to the satisfaction of the trial court. So the learned magistrate shall be at liberty to impose such other conditions as may be deemed appropriate, as may be deemed appropriate.
My lord, we make it 2 weeks is all I'm requesting instead of 1 week, because one of them is based here. Flights are sometimes really problematic. 2 weeks.
Right, 2 weeks.
And one request for discharge will not be influenced by the observations, because there are certain observations on merits.
Nothing, Mr.
My lord. There are some observations on merit, free, etc.
Thank you very much. Thank you.
Grateful.
Please, ma'am. My lord,
Description of sentence.
Yes, Mr.
please. My lord, the first round, my lord, the constables came and the ground was that they were simply following the directions of their superiors. Now, my lord, here, they are the advocates and the advocate was throughout present during the commission of the offense. The High Court records that CCTV is not clear and therefore his presence is disputed, whereas, my lord, there was a test identification parade in presence of an executive magistrate and thereafter followed by, my lord, his identification in the court. And, my lord, my lord, the High Court records the phone which was found and which was used by this person, my lord. That phone was lost by somebody 6 months back. That's also wrong because it is recovered from him at the time of arrest. Please have a look, my lord, at page. And please see, my lord, he was described as an unidentified person and it was told in the first complaint that once I see him, I can identify. Therefore, a test identification parade was conducted, my lord. Now, please have a look at para 14, my lord. Page 50.
Test identification parade, because the FIR was delayed, was after 4 months of the incident.
My lord, there was an inquiry prior to that. There was an inquiry, my lord, and please see, my lord.
Lawyer's presence was not spelled out in the FIR.
No, my lord, please see. I'll just.
Then he goes to the Home Minister and then the FIR gets registered in April.
It was.
We understand that.
Please,
there are some influence, etc. But still then the fact of delay.
Please.
We have to examine the identification in light of the fact of delay between the parties. And admittedly, this person was advising some of your partner.
No, my lord, he was never, my lord. The High Court records that his father was once upon a time an advocate.
Your father was the lawyer of your partner who is accused.
But my lord, he never appeared for me. Please see, therefore I am pointing out, please see para page 15, my lord.
Yes.
Para 14, my lords, may have a look.
Let's just say the point is that in a case where the
My lord, in the first round, my lord, when I pointed out that this may not be treated as a precedent, my lords have clarified in the order that in the peculiar facts and circumstances of the case, where there were constables simply, my lord, following the directions of their superiors, my lord. Here, my lord, please see the police officers and IPS officers, my lord. The police officers are a former MLA is before my lord, my lord.
It's the pendency of appeal. But the appeal will be heard, all these.
No, 4 months, 364A, life imprisonment, the evidence is on record, the findings are flawed.
High Court has made a fine distinction between the conspirators.
Therefore,
the superintendent of police has not been granted suspension. Your partner has not been granted suspension. It's the lawyer, the constable, and the former MLA who have been granted suspension.
But there should be
There's a
findings
clarity
can't
in
be
the-
Lord, contrary by
of
granting
culpability.
suspension, Lord, with all due respect. The findings can't be contrary to the record, my lord. Please see, therefore I am pointing out, kindly have 2 pages, my lord. Para 14 at page, my lord, 15. Kindly have a look, my lord.
Yes.
It says, my lord, the applicant was throughout remained present when the act of ransom and kidnapping being made by the police officials. Hence facts remains that the CCTV footage relied upon the prosecution seems to be not as much as clear. My lord, I was there, I identified. And 2, my lord, now please see the second finding.
Mr. can clarify that this observation has nothing, will have no bearing on merits. But the point is that once bail has been granted, why?
Lord, yes, I can understand, but this is an offense, my lord. Please appreciate a police officer is posted, my lord, 400 kilometers away. He comes to Gandhinagar from Amreli, and then he abducts. Then there is a transfer of Bitcoin where this MLA is involved. The advocate is present throughout the incident, my lord. Even prior to that, in the conspiracy, my lord, in the conspiracy right from 7th of February till 11th of February, they were in constant touch. The person who was released, that is Kirit Paladia, and my lord, this MLA and these lawyers were in constant touch, my lord, on phone. Those are CDRs on record. There were meetings in the circuit house, the government circuit house, my lord. That is all, that register is on record.
Question of connecting this entire evidence to establish that there was a meeting of mind or that there was
there is no
preconceived conspiracy. All these are matter of trial because
therefore, my lord, there was a
substantial evidence.
But my lord, if the findings, my lord, are prima facie in contradiction to the evidence on record, just kindly have a look, my lord, what the learned judge records, my lord. Only one thing. Here, my lord, the High Court records that, kindly see page 16, my lord. What the High Court has recorded. That the mobile number 816, the last digit, claimed to have lost 6 months back. And then please see page 443, it says, there is a finding that further the mobile number so-and-so recovered from the accused Ketan as per the deposition of so-and-so. So there was a recovery, the High Court records that it got lost 6 months back. My lord, the findings are prima facie, my lord, in contradiction to the evidence on record. I can understand suspension, but please see, my lord. So at least, my lord,
assuming it's an erroneous order, even then we should not interfere. Unless we find a complete pervert order, going completely beyond jurisdiction. The High Court
Lord, this is prima facie in my respectful submission, my lord. Once the High Court records a finding which is contrary to the record, my lord, then what more perversity is required, my lord, with all due respect. And please see, and 2 unidentified person, my lord, the High Court records he has not named. I was not actually knowing him. He came in Elantra car, my lord. That Elantra car he borrowed, that witness evidence is there.
That the improved order pertains to suspension of sentence and grant of bail to permissive criminal appeal. We are not inclined to effectuate with the same. Especially
and this may not be treated as precedent, my lord. Now the police officers are in line. At least my lords may say that, my lord. they may not get the benefit of parity, my lord. If at all my lords are, my lord, not intervening, my lord, because of the rules, my lord.
It goes without saying that such a prayer, if made by the who accused who are police officials, or shall be dealt with by the High Court as per their own right.
Please.
High Court has already rejected.
14 and 15, my lord. 15 is. No, the other police officers have not come. Only one, and he has withdrawn. My lord, only one. Only one. That is Kirit Paladia. He is not a police officer.
Police.
No, my lord. Superintendent of police. His application is.
No, that has been turned down.
No, it is
the High Court made
the
a
police inspector, my lord. Not the superintendent of police.
The superior police officer, the constable's bail were granted.
Constables were
The superior
granted.
police officer's bail has been turned down by the High Court.
No, only the
One
police
of them.
inspector, my lord. One of them.
Inspector.
The SP.
SP is two.
Yes, my lord. Now SP is waiting for
The
the house.
inspector is down.
With the addition of this line, they will be taken care of.
Please, my lord. We are grateful.
Please, my lord. My lord, this is a case where petitioner is seeking his right of hearing on the bail application. My lord, what is happening that bail applications are being filed by the litigants, and that is keep on adjourning without taking on the roster because of the heavy roster or any other reason. We have the compilation of एक बार ये देखो दे दो तो My lord, we have the compilation of various cases where such type of practice is being done, my lord. Please, my lord, I have the list. I have prepared on my own. It is not the list of compilation of all such type of cases. But suppose the case is at serial number 3.
Sir, basically, I am to report. So, there is a slightly unusual prayer made in this specific petition. It seems that the petitioner has approved the High Court for grant of regular bail. The petitioner has approved the High Court for grant of regular bail in a case registered under section 115, 190, 191 in bracket 3, 324 in bracket 5 and 351 in bracket 3 of the BNS 2023. The petitioner was arrested in that case on 11th August 2025. His bail application, he approached the High Court for grant of bail and his application came up before the High Court for hearing on 8th December 2025. It was adjourned to 20th February 2026. That is for a period of more than 2 months. The petitioner then applied for preponement, but died in June order dated 22nd December 25. His prayer has been declined on the ground that the bail application of his co-accused has already been dismissed. Next paragraph. During the course of hearing and on a query by this court, Komal and senior counsel for the petitioner submits that there are numerous bail applications pending in the High Court of Punjab and Haryana, Chandigarh, where matters are adjourned where the dates are being given months after, and as such the bail applications are not being decided for a long period. On a further query and on an illustrative basis, he has submitted a chart.
স্টার হেলথ ইন্স্যুরেন্স থেকে আমি বহু সাহায্য পেয়েছি এবং বাবার একটা পেটে টিউমার হয় 2020-তে আমি
which are pending since October 2025 and are currently adjourned to since May 2025 and are currently adjourned to different dates in the month of March 2026. You are for the state?
Yes, Your Worship, I am appearing for state.
It's not your fault, maybe.
Yes, sir.
Your fault may be that because you might be taking date or you might not be producing the record. But these are not the way the High Court should deal with bail application. If you don't want to grant bail, you reject it. For 6 months, for 1 year, you don't decide the bail application.
My lord, I have given the suggested measures also, where the state is seeking time for filing status report and on any other, there are various reasons for which the bail applications are being pending. There can be mechanism, my lord, because 7 days time is always given in regular bail in High Court. Within that period, they should file the status report so that it cannot be adjourned. Because once adjourned, then it goes after 3 months.
We had introduced a system there that when you file the bail, we don't know now, you file the bail application, you will give an advance copy in the AG office, and when after a gap of 1 day, the bail will be listed and the IO will remain present in court.
Earlier it was being listed, but now.
Of course, now with the hybrid system, the IO can appear even online, but the bail application could be decided the very third day.
Yes, but now it is listed after 7 days. And even within 7 days, no reply, no status report, no.
And that's why when we ask for the disposal, only these bail application disposal is shown. The regular matters are still pending there. All 1985-86 RSAs of criminal appeals, everything is pending.
It directly affects the liberty of the litigants.
Next paragraph. ये सारे सर्विसेज से प्राप्त करना चाहिए क्या उन्होंने लाइफ में कुछ प्रॉब्लम At page 22, you can't blame the judge on a request made by counsel of the by the petitioner.
What is happening in some of the case is not being taken up. Thereafter, the counsel check the list. Then what is that on the request of the counsel adjourn and status report is awaited. There are also some of the cases. I have given 7-8 suggestions, my lord, how it can be mechanized or improved.
The biggest problem is that there is no orientation, there is no training system, there is no sensitization program of after all they are high court judges, they must themselves realize it.
My lord, I have given the copy.
ROPs have also been produced in order to show that how the matters are being adjourned repeatedly, how the bail matters are being adjourned repeatedly. Next paragraph. All that we wish to observe at this stage is that we are extremely disappointed to see as how the prayers pertaining to the liberty of individuals are being dealt with. It may be true that the dockets are very heavy and there are other matters which do require prioritization. But amongst the miscellaneous matters, nothing can be more important than the decision of the fate of, nothing can be more important than deciding the fate of the prayer to grant or refuse bail. Next paragraph. We expect Honorable Chief Justice of the High Courts to take some remedial measures. इससे पहले कराया डर ऊपर almost shocking. Don't say shocking, okay? It is equally disturbing to know that in the Patna High Court, bail applications are not listed even for preliminary hearing for months. And more than 14,000-15,000 matters are pending. One of us, Mera Likho, vividly recollect various matters coming to this court only for seeking direction only for listing of their bail applications before Patna High Court. We have no reason, next paragraph, we have no reason to doubt that Honorable the Chief Justice of the High Courts are cognizant of such prevailing conditions where the High Courts unfortunately are not even able to decide bail applications on time, within a reasonable time. This is happening despite the fact that on occasions, this court has indicated timeline for adjudication of such type of matters where there is an inbuilt urgency, keeping in view the very nature of the relief sought. It seems that those orders passed by this court have not been able to bring the desired sensitivity as a result of which, due to which, the high courts have apparently not evolved any robust mechanism for time-bound adjudication of the bail matters. Next paragraph. We are conscious of the fact that listing and prioritization of the matters for the purpose of listing is the exclusive prerogative of the Chief Justice of the High Courts, they being master of their respective rosters. So, however, if the people are languishing in jail, semicolon, their bail applications are not being even heard, and they are completely in and there is a complete uncertainty as to when will they be able to know the fate of their applications, comma, it seems that this court is under a bounden duty to lay down certain mandatory guidelines. However, before we do so, we direct the Registrar Generals of all the High Courts to send complete details of the anticipatory and regular bail applications pending in the respective High Courts, along with the date of filing, date of decision, or the next date of hearing. All the bail applications, such details shall be furnished for the time being in respect of all the bail applications which came to be filed on or after 1st January 25, filed on or after 1st January 2025. So, bail applications filed prior to 1st January 2025 are also pending. यहाँ पे है ना anticipatory bail application then stroke है ना application for suspension of sentence. Three categories. However, if such applications filed prior to 1st January 2025 are also pending, details thereof shall also be furnished. Next paragraph. Adverting to the case in hand, however, we find that the bail application filed by this petitioner is coming for hearing on 20th February 2026. may request the Honorable Judge to decide the same on merits, either on the date fixed or prior thereto, if an application or prior thereto, provided that the petitioner seeks postponement of date. Next paragraph. Within 4 weeks, post the matter for further consideration on so and so day. उसमें लिखना, all the state governments are directed to fully cooperate with the High Courts for early and time-bound adjudication of the bail applications, stop prayer for suspension of sentence. The High Court shall sentence the states should be ready with the relevant information as and when the bail application is listed for hearing, provided that a copy thereof has been handed over to, has been submitted in the Office of Advocate General and or the public prosecutor at least 3 days in advance. At least 3 days in advance. In such like matters, the investigating officers or the authorized officer can be permitted to appear online also. That's correct. The Registrar General of the High Courts are further directed to circulate disorder amongst the honorable judges of the High Courts with our fervent appeal to them for expeditious disposal of the pending bail applications. Next paragraph. The Honorable Chief Justices are also requested to revisit their roster stroke listing arrangements, and wherever they find that there is a mismatch between the total pendency and the bench allocated for deciding such matters, they may consider the desirability of listing the bail matters before.
ગામોના વિકાસની દિશા ગામ પોતે નક્કી કરશે. વિકસિત ગ્રામ પંચાયત પ્લાન્સના દ્વારા યોજનાઓનું થશે પીએમ ગતિ
post the matter on so and so date.
May I make one more submission, my lord? My lord, in cases of suspension of sentence, sometime what is happening that custody is more than 7, 8 or 10 years. Suspension of sentence bail application either pending or disposed of by listing the appeal. But appeals are also not being heard. And 7 years custody, 10 years custody after conviction of total, my lord may also call the record. The appeals in which custody is almost.
Right, Dr. Pankaj, that there are the system that has its own difficulty. If you start taking your only criminal appeal, the matrimonial appeal, the matrimonial cases, the other admission matters, academic matters, those get delayed. Some balancing has to be done.
There is no doubt that that is heavy roster, but 10 years custody is something.
No, undoubtedly we don't, we strongly disapprove rather if there is custody of more than 10 years, even normally in a case of life sentence, barring a few cases where death sentence is there or the crime is so heinous that life imprisonment means that he has to spend 40 years or so. In such cases, there is no question of granting bail. But then you pass an order, dismiss it, matter ends. Somebody with applied, they have a right to go and appeal, let them come. But keeping pending is what is bothering us. You pass an order, that is prerogative of the judge. Whatever order they want, they let them pass. Right, let us see
items 36, 37 are those Bengal SRs. In the sequence, it was supposed to come after 16. So, is that being taken up?
We'll take up to.
Because the sequence was issued this morning. It said it's after item 16. Items 36 and 37.
After this,
fresh matters.
1 or 2 fresh matters are left.
Yes.
After that,
these are fresh. 36, 37 are fresh matters. Bengal SIR.
Those have been pegged with us.
I am grateful.
Just a minute, only 2 matters are left.
Very well.
I am grateful.
Yes, item 40.
Yes, sir. I appear for the petition.
You can argue from there now.
Only difficulty is, my lords, the elections are slated to, my lords, on Friday. My lords, my objection was dismissed only on 22nd. But on 23rd, immediately I have moved the High Court. Immediately before the High Court, I have moved on to the very next day.
You want to oust your opponent at this stage of nomination itself.
No.
You don't want to face in the election.
No, my lords, the only difficulty is that, my lords, I have moved the High Court immediately on the next day. My lords, no hearing has been given.
If you win the election, then he is out by itself.
That is it. May I only make one request, my lords?
23rd
Options open.
I'll withdraw this petition. My lords, only request is that, my lords, this objection I may be allowed to raise at an appropriate stage. Because one of the difficulty I'll face otherwise is that the order of the returning officer which is against me.
Counsel for the petitioner seeks and permit to withdraw this petition with the liberty to raise all the to raise all the contention at an appropriate stage. Order to court.
Very. I am highly grateful.
Item 41.
Lordship, almost more than 90% encroachment has been removed from the government and forest land, Lordship. This fact is already acknowledged by the respondent number 225, Lordship. May I read, Lordship, annexure P5, Lordship? Page number 36, Lordship.
But why not remaining 10%?
Actually, Lordship, there is a one beam, Lordship.
My lords, I am appearing for R1, my lords, for Miss Chandel, my lords. My lords, my only 2 submissions, my lords. The first is, my lords, in the month of May.
That pillar of the house.
My lords.
Beams.
My lords.
Normally they don't construct pillar in Himachal.
My lords.
But that beam or whatever support to the roof.
My lords.
That is coming in the government land.
My lords.
And if that is removed, the entire house will fall down.
My lords, they were new while they were constructing, my lords.
Right, they knew that.
Who is the Lordship?
They were new the consequences of my lords. Still they constructed, my lords.
Who is the Lordship? In which capacity is appearing?
My lords, again in the month of January, my lords, the petitioner again encroached the government land, my lords. They are using as a warehouse. They have kept their the materials, my lords. They are
issue notice. returnable and so on. So that you appear for whom?
My lords, R1, my lords. Miss Chandel, my lords, R1.
R1.
My lords.
Or you are the complainant?
My lords. Original petitioner, my lords.
Then say, so and so accept notice on behalf of West Bengal. Counter affidavit can be filed within 4 weeks. Then say, meanwhile, the parties are directed to maintain status quo at the site. That means that neither the house of the petitioner shall be demolished, nor the petitioner shall be permitted to raise any fresh construction. So, if the petitioners indulge in raising fresh constructions, respond number 1 and the authority shall be at liberty to bring it to the notice of this court, and in that case, the petitioner will be liable to face the consequences.
My lords, meanwhile, they kindly directed to remove the, to clean the, my lords, the path, to clean the path, my lords. They have,
No path.
as per my instruction, my lord, they have kept their
There is no path.
materials to construct the buildings.
You take out the photograph, you will file counter affidavit and you place on the court the complete site plan, photograph, and show that how the passage has been improved. Then we'll see what is to be done.
Obliged.
Deeply obliged, Lordship.
West Bengal.
Very 36 and 37 are fresh matters. 21 is after notice.
Judge, may I just prepare a note? I'm appearing for the petitioner in 37 and also in 21.2. So I just have a note because we need some urgent orders here. So would your lordship please just take this up along with, I'll request the court master to hand in IA 26838 of 2026. You got a copy of the note?
21 is on the board. That's also that's also ECI 21. The
21, you are appearing in item 37.
I'm appearing in 37, but I'm pressing just now because this is a matter.
37 is by Madam Mamata Banerjee.
Yes. And
there is another matter, 36 by Mr. Joy.
I'm in 36. I'm in 36.
Yeah.
32 petitions.
Well, it is connected to 21, and I'm requesting the court master to hand over 21.2, IA 26838 of 2026. So, because the cross references in my note are to those particular documents, so I'll just request that. And I'll place this quite rapidly, along with the writ petition. And there's an earlier IA also, 1884. Would your lordship have the note?
Note. All right. Yes.
Now, Manoj, with your permission, may I just place, Manoj, since Manjoli was not there on in the bench on 19 January 26, may I just place this court's order of 19 January 2026?
19 January, is it the same order when Mr. Sibal wanted us to issue some direction?
Your lordship will already pass direction, so this is just in furtherance of that. Your lordships have that. It's at page 30 of the IA.
Page
30.
That's it.
IA 26838. Your lordship has that?
Yes, yes.
Yes. Justice Patwari, I'll just go through this so that we'll get the thread.
Order starts from page 31.
That's right. Para 2. It appears that approximately 1.40 crore individuals have been issued notices for the purpose of document verification. These notices are broadly categorized into 3 parts: mapped, that is the category of voters who are linked with the 2002 SIR; unmapped, that is the category of voters who are not linked with the 2002 SIR; and 3, the third category involves logical discrepancy, accounting for approximately 1.36 crore voters. The documents brought on record by the parties indicate that within the category of logical discrepancies include inter alia mismatch of the father's name, a mismatch of the parents' ages, a difference in the parents' ages of more than 50 years, a difference in the grandparents' ages of less than 40 years, and those having more than 6 progeny. With a view to enabling the person who are, as of now, included in the category of logical discrepancies, we deem it appropriate to issue the following directions, The names of the persons figuring in the logical discrepancies may be displayed at the Gram Panchayat Bhavans, public places in every taluk and block office and every taluk subdivision, as well as the ward offices in the cities and the urban areas. Persons likely to be affected are permitted to submit their documents, objections through their authorized representative. Such an authorized representative can even be a booth level agent. There shall be an authority letter in favor of such representative, whether signed or thumb marked. Documents and objections may be permitted to be submitted at the Panchayat Bhavans of block or block offices. The Election Commission of India shall issue instructions for providing an additional 10 days time for the date of displaying the list in a Panchayat Bhavan's block office to all persons who have not yet submitted their claims, documents or objections to do so within the extended period. The state government shall provide adequate manpower to the Election Commission of India and the State Election Commission for deployment of Panchayat Bhavan's block offices to handle documents, objections, and hear persons likely to be affected. In this regard, we direct each district collector to meticulously follow the instructions issued by the Election Commission, state government for deploying adequate staff and forces for ensuring smooth functioning. Director General of Police, West Bengal, Superintendent of Police in the district and the collector are instructed to ensure that there is no law and order problem. All affected persons may, in addition to being given an opportunity to submit documents, materials or objections, also be heard at the time of either in person or through the authorized representative accompanying them for the purpose of making an appropriate decision. The official will receive the documents or record a hearing to the affected person, may also certify the receipt of documents, and that important direction in para 10, Madhyamik class 10 admit card, which discloses the date of birth of the candidate, may be submitted apart from the Madhyamik pass certificate.
Section number 10 was issued.
Yes.
Because we, at least personally, I had the advantage of my two brothers from West Bengal being with me.
Yes.
And they were able to point out that this is the way in certificates are issued in West Bengal.
That's right.
Therefore, because of their having been pointed out, so that's why we included in 10.
Now, Manoj, may I request you to take up the note so that we just very quickly and rapidly go through that. So, please see, this is a brief note on behalf of the petitioner. Your Lordship has it. That's the heading, right on the cover page. Sorry. Of the note, which is a snapshot. Now, the number of days left for the final publication.
Separate note you are talking.
Yes, but just save time. This is the full the submission which we are going to make and the request. Number of days left for final publication of electoral roll is 11 days. So that's up till 14 February 2026. Number of days left to complete the hearings is now just 4 days left on 7th February 2026. Number of voters categorized on a draft roll as unmapped is 32 lakh. Number of voters categorized as logical discrepancy post-draft poll publication is 1.36 crores, which is 20% of the electorate of West Bengal. Number of hearings held since, now this is just to give you an idea, since 16th December 2025, which is 41 days, so far they've held 88 lakh hearings in respect of 88 lakh voters, which is at the rate of 1.8 lakh per day. The number of hearings pending is approximately 63 lakhs. And this will mean that if we are to, which an endeavor would have to be made, if we have just 4 days left, they will the speed of verification will have to go up to 15.5 lakhs per day, because there are just 4 days which are left for 63 lakh. Documents pending for verification at the DEO level in 11 days from 88 lakhs hearing completed. So we have indicated that number. Documents verified by DEOs in 41 days was 52 lakhs. Number of, now just note this because there's a set of submissions here. Number of micro observers deputed without any statutory basis. This is 8,300. I'll make a short submission on this micro observers because they don't seem to be contemplated under the constitution at all. Even under their manual of operations, it's a very, very limited role which they have on election day. But not the activities which have been deployed right now, which has been given to them at this stage. Number of approved documents rejected after hearing stage commenced. Now, this is one of our grievances. The Panchayat residence certificates, the family registers, the domicile certificates, Aadhaar card, OBC certificates, and land allotment certificates. None of these are by themselves being accepted. And despite orders of the court, and then, Millards, we have mentioned because people are waiting in 4 and 5 hour queues over there. Now, please go over to page 2, para 5. We formulated the specific point here. Now, the first suggestion is non-statutory category of logical discrepancies used to issue notices to 1.36 crore otherwise eligible electors. Now, this is our request. Direct the ECI to upload the reasons of each elector flagged as logical discrepancy cases online on the ECI website. May I request you to directly go to page, we explained this more fully, but just go to page appendix 1 at page 8 of the same note. Now I'm just giving you an example. Appendix 2. My mistake. Please go to appendix 2. Appendix 2. Page 11. Page 11.
Page 11.
Yes. Now, pursuant to your lordship's directions, this is what is being put up. But as you will see, so the name of the elector is there, age, gender, and then the category notice just says DM, which is discrepancy in mapping. But the person doesn't really know when this is put up on those, but the reasons are not indicated over here. So what is the reason for this particular discrepancy in mapping?
Mr. Divan,
yes.
We were informed that this is on the website, but when the notice is given to the person,
yes, you're right.
The particular
yes, I've given you that example. You're right, but there is a lag as far as those notices are concerned. So we are suggesting some short reason should be indicated on this as well, because it will help the process. People will know why are they on that particular list. What's the reason for the list?
Super.
Yes.
To the extent that person must know the reason.
Yes.
It is absolutely justified. There is no difficulty. The only question is that what is the mode of communicating that reason? What we have been told on the day, because on 19th when we were passing this order,
yes,
we were also, because we thought that we are issuing very comprehensive direction so that there is every procedural part is smooth sailing.
Yeah.
Now we were told on that day that this is, the list is not the only communication. Communication is individual notices to the person included in the list of discrepancies.
Yes.
And that notice then defined. That notice.
We've given you a sample in the note. You're right. You are absolutely right. For example, page 9 and 10.
All notices.
Is up there on the note, and a short reason is indicated. The notice may carry, given the numbers which we are dealing with, by the time somebody receives it, reads it, etc. So this is my first suggestion.
So for example, page 9 as you are referring.
Yes, page 9, we've indicated over there.
Now it said due to the mismatch between the name of your father as the current electoral roll and as given in the electoral roll prepared during the previous SIR. As per the linkage shown in your enumeration form, you seem to be incorrectly linked with the electoral rolls. I think this is a reason, a well-explained reason.
So now I want to just take this. I'm obliged to your lordships. Now please go back to my note. Just go to page 2. I'm going to now build on this point.
Page 2.
Yes. So on page 2 of the note, 5A1, I have made the point. Then your lordships will see upload reasons is what we suggest. Now number 2, in 5A2, direct the ECI to withdraw all notices under the category which pertain only to name mismatch. Now look at this. Yeah.
Page 5. Page 5. 5.
I have nothing to say.
5K.
Yes,
This A then close to.
yes.
Where you are
The name mismatch.
Are you referring to the cases? Say for example.
Yes.
Just on illustrative basis.
Yes.
So for example, one person writes Datta.
Yes.
Somebody may define, may spell it as D-U-T-T-A. The other way spell it D-A-T-T-A.
Absolutely. Yes.
That is one part.
Yes.
And similarly, Banerjee, similarly in Sarma,
Yes.
somebody may write SH,
Yes.
somebody may, many of them write SARMA.
Yeah, so your lordships have exactly anticipated what we have set out in paragraph 7A. In fact, we've given Datta, Ganguly, Roy and Ray as examples. But we've given actual examples of what is being faced at page 8.
But
Now,
according to you, you see,
look at, sorry. One is
tell
name
them to
mismatch.
withdraw the notices will be, is something very impractical thing because notices have been issued.
No, I'm suggesting. My suggestion is that our estimate, it's an estimation that in the logical discrepancy cases, please go to paragraph 7A on page 4. Just go to 7A of the note, page 4. A majority of the logical discrepancy cases, more than 50%, which is around 70 lakhs, are cases of minor name mismatches and spelling variations. And we've given the very examples. Page 4 of the note. 7, subsection, para A. A majority of the logical discrepancy cases, more than 50%, are cases of minor name mismatches and or spelling variations, and your lordships knows. Now we've given you an actually of actual electors. Please go to page 8. This just builds on the point which your lordship made. Please go to appendix 1, which is page 8 of the note.
Page
8. Now, your lordship has it. So now Mr. Chirag Tibrewal, his discrepancy was father's name mismatch. My father's name was Kumar in the middle. Your lordship has it. Last column. My father's name has Kumar as the middle name in the 2025 SIR, which was not there in the 2002 SIR. I have been served a notice and called for a hearing on 27th January. Look at serial number 5.
3, just see 3.
All right, 3. Well, let's please see, this is Ajimuddin Khan. Now let's see what has happened in his case. Father's name is shown as KHA, Alauddin Khan, in the Bengali, whereas it should be Alauddin Khan. Because, you see, from Bengali into English and vice versa, you can lose this. Yes. This may be software.
Illustration number 3 may be slightly difficult. Because here you are saying Azimuddin. No, Azimuddin is...
It's Alauddin. Father's name, father's name.
So the spelling mistake is, or spelling difference is in the name Alauddin Khan.
No, that's his father's name. Please just see.
The Chandramatra there.
Yeah.
मेरा बेटा ईशान डॉक्टर बनेगा डॉक्टर मेरा ईशान तो साइंटिस्ट बनेगा अब ये ईशान क्या बनेगा
ईशान कुछ भी बने उसके साथ हमेशा है LIC की अमृत बाल चिल्ड्रन पॉलिसी बड़े सपनों का रखे ख्याल।
The 2002 electoral roll was in Bengali. So when they translated it for this purpose.
Can be. All right. What is your solution? Because then we are also thinking.
No, because there are 2 ways of looking at it. One is, look, this name discrepancy, my lords, which is the bulk of it, is cramping even the available time, which is just a few days. So these name discrepancies, my lords, should not be within this logical discrepancy to knock out people from the electoral roll, because look at the inconvenience. Look at one of those notices.
Your solution, Mr. Dwivedi, have you think about it?
Actually, more than 80 crores hearing have already taken place. Few more which are left.
No. What about this kind of discrepancies which are not even a spelling mistake, which are only on account of how you speak in the local dialect? This happens pan-India. It happens in Haryana also, it happens in Punjab also, it happens in West Bengal, it will happen in Tamil Nadu also.
Yes. So we don't have instructions
Because-
being chart given to us just now, but it's not there in the IA, yes, etc. But ordinarily, what my instruction.
So, Mr. Diwan, let's find out.
Because name mismatch is not being
I don't want to interrupt. I don't want to interrupt.
Please don't purge people.
Mr. Sibal, you are unwell today, you better take rest.
I am going to, Malad, I don't want to interrupt your watches will remember, Mr. Dwivedi made a solemn statement, and where is this kind of discrepancy, we're not going to bother about it. Your watches will remember that. He said if it's a question of spelling, I am not going to, this is not something that will be.
Only if you were in Bengal, Mr. Dwivedi, you will be pronounced as Dwivedi. D will become B.
And you will also be ousted.
Yes, then you will be expurged.
Language doesn't have a war.
Gujarati become.
Bengali language doesn't have a war.
Instead of my brother being addressed as Vipul, they will address as Vipul.
On this aspect, may I just sorry.
But my name, there will be no mistake, because it's a basically Bengali name.
Sir, it may be, sir. Sorry, sir.
With your
Because
what
you-
question could we just have an insight over your Yes, please.
5 minutes.
If you allow me.
So, go ahead.
So my understanding was that mere spelling mistakes notices are not being issued.
Are being sent.
But now that this chart is being issued, is shown to your lordship just now, I need to get an instruction. Your lordship may have it tomorrow or day after, whenever I can.
The executive head of the state is also very much present. If the state government provides a team of officials who are well conversant in Bangla and who are well conversant with the local dialect,
Yeah.
and they scrutinize these, just scan through this and tell the commission that this is here only a local dialect mistake
Yes.
and not any identity mistake.
Yes.
That will help them.
No, it will help them, but it's apparent. Actually,
Apparent in some of the cases on illustrative basis it may be, but it will become humanly impossible for you or for us to go through and to.
May I explain you, sir?
Give me time till tomorrow day afterwards, then I can get that.
May I explain you, sir?
Because in my view,
Because I belongs to that state. I am a.
Can there be any doubt, madam?
No, sir. No, sir. I am very grateful, sir, because of your kindness, my humble regards to my Honorable Chief Justice, Mr. Babchi and Mr. Panchali ji also. Thank you very much. And my humble regards to Mr. Dwivedi and others, my opponent lawyers also. Sir, the problem is, always our lawyers fight for the case and they're fighting from the beginning. We are also. But sir, when everything is finished, when we are not getting justice, when justice is crying behind the door, I quote Rabindranath Tagore, then we thought that we are not getting justice anywhere. So many times I have written 6 letters to Election Commission, including all the details, but no reply, sir. I'm a bonded labor, sir. Maybe I prefer that. I'm a very less important person. I prefer that. Sir, I'm from a common family, but I'm not fighting for my party.
Madam Mamata, sorry for interruption. The state of West Bengal, in its own right, has filed a petition, right? Today, of course, you are also coming in your individual capacity, but state of West Bengal, in its own right, there is nothing wrong in that. State of West Bengal has also filed a petition.
State of West Bengal is not.
One of the best concerns in the Supreme Court, fortunately, are there to.
The villages of India are the soul of country. Employment schemes do provide work to the villages, but now with changing needs, villages need new direction. Modi government's unprecedented move, Vikasit Bharat, the G Ramji Act 2025. Now every rural family is guaranteed not 100 but 125 days of assured employment, guarantee of unemployment allowance, guaranteed compensation for delayed payments. Our resolution, Vikasit Bharat through Vikasit Gram Panchayat.
Yes.
January, on 19th January when the matter came before us, Mr. Sibbal very eloquently he explained the procedural difficulties which the state was experiencing and where the state had some genuine apprehension for exclusion of the bona fide citizens of the India, citizens of West Bengal, the residents of West Bengal who are citizens of India. So therefore those directions, the direction which Mr. Diwan just read out were issued. Today, in your petition, some additional issues are being flagged. Absolutely right. Issues are being flagged. Every problem has a solution. So we must look toward the solution in order to ensure that no innocent citizen is left out. This SIR is based upon only on 3 grounds. Dead persons excluded, no difficulty, neither you will want, nor anybody will plead for the dead persons. Similarly, the persons who are disqualified to remain for any reason, somebody is convicted, whatever may be any ground in the law, you will not plead their case. Similarly, those migrants, the word is migrants, migrants is also one of the ground. Those who have left West Bengal, even you will not plead there. But the genuine persons must remain there. Now, among the genuine persons, one of the ground, as Mr. Diwan has today flagged, and rather we are thankful to you also that in your petition now this issue has been raised that because of the local dialect or because the manner in which the Bangla people will proudly pronounce a name or because of that, and this all because nowadays AI assisted computerization that you are speaking Datta and they are recording something else. If this kind of things are happening, we will find out a solution. They will have to find out. They can't. They will not like to run away from that responsibility. That by virtue of this kind of mistake, the genuine and bona fide person must not be excluded.
Sir, what happens now?
Only one.
Sir, what happens now?
Permitted before they could open millets. Insofar as the Election Commission of India is concerned, I represent. In that matter, so far we have not been served with any pleadings. We are clueless what their grievance is. If it's been there, if it's served on us, a week's time given, we'll get all instructions, we'll place it before your lordships, and look forward to any genuine difficulty to be redressed.
Week's time will be too late.
So be it, millets, let it be on Monday. Let it be on Monday.
Sir,
because millets were clueless what the grievance is.
Sir, this is not.
I understand.
Please allow me, sir.
The reply in 21.
You are right in saying that you have not been even given copy because
No.
that is coming first time for hearing.
Indeed.
The only thing is that since all this entire procedure has a timeline, at that timeline we had extended on 19th January for another 10 days.
2 minutes.
But that 10 days time is also now because they rightly pointed out by Mr. Diwan that out of that extended period only 10 days are left. 4 days are left. After those 4 days, only 11 days are left. So this being a timeline, we can't grant you the luxury of 1 week notice.
Minutes on Monday, so that sir, we'll come to know what the grievance is and we'll suggest or place before your lordships the remedial
Sir,
measures.
please allow me to finish my point, please.
In principle,
Yes.
if it is happening that Roy, Datto, Ganguly, Upadhyay, anyone like this, by virtue of the local dialect, if the name is being spelled out slightly different than what the accurate words might be, somebody can say.
Precisely.
In a given case, we do not know how Tagore is also defined. Maybe somebody put the E in the last, somebody may not be putting E. But that does not mean Tagore is not Tagore.
Millets.
So, you also have to come out with a...
What they cannot afford to forget
So is the state council justice, so we will...
Millets, even the field staff are local, they pretty much know all
Respected
this.
Chief Justice, sir,
Not that
I am
imposed.
giving you the example. I can show you some photographs. If you allow me, only I want to submit, sir, I want to lay, because it is not my photograph. All the Bengali leading newspapers, it is reported. You will be surprised to know the, sir, only sir, my submission, sir. Sir, their SIR process is only for deletion, not for inclusion. Mismatch not only the title, sir. mismatch, mismap, unplanned. Now suppose a daughter after marry, she go to the in-laws house. Now why she's changed her title? Why she's using the husband's name, husband's title? That is also mismatch. Yes, sir, they have done it, sir.
That's why we are.
Now,
That's
sir,
why we.
only just want to, sir. Number two, sir, there are some daughters who married and shifted the in-laws house. Their number also just unilaterally deleted. It is just because they shifted their houses. Sir, you will appreciate sometimes some people work some office, they go to they transferred other offices, they work somewhere. Sometimes the poor people they purchase the flats, they shifted their addresses, but there the genuine people are staying there. But because of the name of logical discrepancy, now they change the name. No, instead of logical discrepancy, when you gave order, sir, they violated, and they say it is the discrepancy mapping. Sir, can they even violate your order? Number two, sir, we are grateful. Bengal people are so happy that this court gave order that Aadhaar card will be one of the proof documents. But they said no, on with Aadhaar card. Sir, in other state, sir, the domicile certificate is allowed. Sir, the family registered card is allowed. Sir, the government housing card is allowed. The health card is allowed. The bank books means whatever caste certificate is allowed. Only they targeted Bengal on the eve of election. Sir, four state opposition state are going for on the eve of election. But why? After 24 years, what was the hurry to do it? What it takes 2 years, only within 3 months, even when the festival season is there, when the harvesting season is there, when people are not in a mood to be in the city, they were in the outside, but they are traveling, and that time they issued the notices and all this. Sir, more than 100 people died, sir. Can you imagine? Sir, BLOs died and they have written the letter that CEO is responsible for my committing suicide. So many BLOs are murdered, they died. And also more than 150 people died and so many are hospitalized. Sir, because of the harassment of the people, because of Bengal is targeted, sir. Sir, you tell me why not Assam? Sir, why not Assam?
The state government, we cried foul, saying that
why not Assam?
need cooperation. They say,
why not Northeastern?
Madam has come all the way to speak something.
Indeed, madam. But the only thing is that, if it's off the record, we need to.
Madam Mamata, let me clarify 2-3 things to you. About the Aadhaar card, this matter is about SIR's validity issue. SIR's validity issue is being argued before us from last more than 2 months. In the main judgment, which was the first case, we have reserved the judgment. Therefore, we are not in a position to comment with regard to the credibility, credential, or admissibility, and to what extent about the Aadhaar card. That issue has been argued before us. We have reserved the judgment. But you also will appreciate Aadhaar card has also its own limitations when you will read that statute under which it is issued. At the same time, with reference to its insertion in the RP Act, what will be its value? We are yet to determine that part. You have one part. Second, you have pointed out this issue of the discrepancy part. In this case, one way out can be that you give a team of officers, the election commission can take them on deputation in the sense that those can also be part of the election commission team, verify that here it is a spelling mistake or it is only because of the local dialect that this mistake is occurring. Those must be rectified. That has to be rectified. So let us see what response they will give. We will grant them 1 day time. Tomorrow,
sir,
after.
No, sir. What happens, sir, ultimately, in practical, ERO has no power now. They have superseded all the power from DO, ERO, BLRO. Only they have appointed 8,300 micro observer and the role observer from the BJP ruled state, so that DO cannot clear the name. It is all micro observer can delete all the names sitting inside the Election Commission office through AI. Sir, earlier 58 lakhs are being deleted. Even they were not allowed to file Form 6. Sir, earlier first phase, 58 lakhs deleted. There are so many people are alive, and now they are being declared by that they dead. Sir, the anti-women, so many women.
Madam Mamata, if need arises, we will mandate it, we will direct. Every document will have to be signed by the BLO, who are the authorized officers and who are the authorized notified officers.
Kindly see the directions on the website, Millers, so far as the so-called micro-observer.
Micro-observer is a final authority. Election Commission, WhatsApp Commission. WhatsApp Commission is saying it is only the micro-observer. Only they are deleting all the names.
They could certificate on record.
They are all government of India officials.
My lord,
They are,
even
In one of the matters, government is a party.
and the problem is that they are not allowing the people.
Let the matter.
They are not allowing the state officials.
For most of the
They are not allowing the domicile certificate. They are not allowing the government certificate.
let that be a direction, Millers, we should be served the copies.
I just highlight.
I have something.
Yeah, I just want to highlight 2 points. If your lordship would just take up, I want to save time, so just go to my note for a moment. Just go back.
But I want to intervene for 1 minute, if your lordship permits, Lord. We have written several letters to the state government to give us Group B, Lord, the class 2 officers of the rank of SDM or equivalent, so that, Lord, EROs can be appointed. That's the standard pattern, Lord, that they should be class 2 officers because they decide vital rights, papers and all.
No, that has
Now they have given, Lord, only about 80 officers of that rank. Rest, all of them were given who were clerks and below, who were working under the pressure of the state government. Therefore, we had to appoint, Lord, micro observers who can assist, Lord, in case, Lord, they are in the confusion. So the fault lies with them in not giving us class 2 officers for performing the job of AERO and ERO. So that's the reason why this is happening. And these micro observers are validly appointed under Section 13C, read with 3.
No, there is no statutory rules.
My learned friends are not right, Lord, that they are not, we are not entitled to appoint them. If this is the state of affairs, which is not contemplated by the rules and the state is not cooperating, then there is no alternative except to appoint the observers who can assist. Class 3 officers from Anganwadi and so on, they are being given to us. So that's
And
the
this is the
reason why
communication.
assistant.
There is only one. But they are not assisting. There is they are taking one. They are taking one side of the story. May be true, may not be true. I'll not go into it. There is one more petition where the Election Commission of India has filed an affidavit. So that also may be taken on record. It's not listed on board. It was mentioned by Mr. Giri. But I am appearing in that matter and I have read the affidavit. So that also will have some bearing, my lord, in ultimately what your lordship passes the order.
And we have highlighted all the injustices we have been facing, Millers.
My lord, my lord, my lord.
My lord, it is pointed out the
I just have 2 minutes. I just
all
want to
observers are
highlight.
victim, that's all, my lord. I am saying let us confine.
No.
Ask them to at least 2 days time we'll have to give
Yes,
them
yes.
to seek their response.
Sir, matter is not correct, sir.
Survey copy, Millers.
But fair enough. What I'm highlighting is just 2 things so that your lordship sees them.
Let me say this, Lord, there is no problem of time, Lord.
The first
Have some buffers if there is
Arey bhai, eta
more than 1 crore already heard. And if somebody is not heard, your lordships are there and we are, our power is
We
there.
have been extending time. We have been extending time. We have been-
My lord, have asked a slew of directions.
my lordship, with my humble regards. May I tell you, sir,
Whatever they have pointed out.
my
and
opponent lawyers raised.
that.
Sir, sir, that is not correct. That is not correct, sir.
Madam Mamata, we have no doubt about the ability of Mr. Diwan. He is one of the best senior counsel you have chosen.
Yes,
Let him
with his
assistance
permission.
on your behalf.
With his permission, sir. Only one thing, sir.
Your point we have well taken.
Sir, it depends on some district, some states, sir. We have suppose 44 district. We have 23 district. Now SDM is depends on the district wise. Now whatever we have the strength, we have included all. We are cooperating to them all. My group.
To provide class 2 group.
Yes, we have given, sir. Whatever they are, we have given. But they are telling
All right. Please.
what I don't believe.
I think we will be able to find out a practical solution.
Very well.
On Monday when we take up this matter, we are granting them 2 days time to have instructions based upon these all the notes and information which you have gathered.
Very well.
And you also on Monday, please give us the list of the Group B officers which you are in a position to spare and to provide to them for their
Furnish it in
assistance.
advance.
So that
And your lordships may list that matter also because
Yes.
there is direct bearing on that.
I see.
There is an atmosphere of hostility, election commission says.
And it contains all our communications to the government,
Written
trying for help.
issued contemporaries.
issue notice.
I have one apprehension, that's all I have. I don't want Mr. Dwivedi coming on Monday and saying, now we have finished 1.2 crore hearings as a figment of his
It's all right.
numbers.
We are entitled to our defense.
That's what you said.
That's an ongoing exercise that will
Sir, only my last submission, sir. Sir, what about they have only first place 58 lakhs deleted. They didn't have any scope to appeal even Form 6. Number 2, the second phase, 1 crore 30 lakhs. Only my request would be, whatever the system is maintaining the other state, they are only targeting Bengal. Only for Bengal, they appointed these micro observers. Yes, for to bulldoze the West Bengal people. My humble submission will be, sir, the logical discrepancy case not to be deleted. And there should be, as it is, it should be cleared by the DO and the ERO, not with the micro observer, not with the roll observers.
Well, let's take as well see your lordship's directions on the last occasions.
give us the list of the officers whom you can spare.
Yes.
Whom you can spare.
Yes.
Probably, once the officers are made available,
Yes.
then micro observer will not be required.
Not be necessary, absolutely. Yes, absolutely.
Whatever the
And
role
on
they
Monday
are
itself, we are taking up the matter on Monday. Meanwhile, they will also get instructions and you also give us that list.
Very well.
Mr. Diwan, please ask your junior to give
Yes.
complete set of paper book.
Of course.
In both matters, we
Both matters. And in Mr. Gopal's matter, very learned
Or with my humble regards, I convey my great regards
pain.
and I will just tell safe democracy.
Joy he is a renowned author, Jnanpith Puruskar awardee. There might be some mistake. Please, you tell your officers also to be a little bit sensitive.
We'll examine, Millet.
Don't issue notice to persons like.
We have never been divorced from common sense. We are addressing them.
Some
If they
extra
want to
time
make
required to
sensationalism,
spend.
that's
So just one last thing I want to flag. When we argued the merits in Bihar, your lordships noticed this logical inconsistency, etc. were not issues there. The problem is, every time a new state comes up, there will be a new issue which has absolutely no constitutional.
Every day changing the decision.
state may have its
Now,
own
after
problems,
this, we can
as they have been creating.
new issue.
Yes.
Every state will have some new issues.
Exactly.
It is bound to be also.
But it has to have a legal basis.
During the course of hearing, it is pointed out by learned solicitors of India that there is another petition hearing number so and so, and the issues raised therein or the affidavit filed by Election Commission of India will have some bearing on the merits of these cases. Consequently, that order petition is also ordered to be taken up along with these cases on Monday, due to date of the Monday. The parties shall have respective instructions on the date fixed.
Great.
Take up on Monday.
Grateful.
Thank you.
Sir, we are very grateful, sir.
Madam,
No, of course, sir. Of course, sir. Please protect the people's rights.
Beautiful.
আমি কোনো ভেদাভেদ করি না, না ধর্মে, না জাতিতে, না বর্ণে, না লিঙ্গে, না পাহাড়ে, না সাগরে।